expatriate law, he worked as a leading barrister in central London for over 10 years. Having now been based in the Middle East for several years, he has an expert understanding of the local law and culture, which he applies to his representation of expatriates in family law matters all over the world. Andrzej Bajarski is a barrister, civil and family law mediator, and family law arbitrator at 36 Family in London. He specializes in high value, complex and international family law matters. He also writes and lectures extensively on English family law. Dr. Hassan Ilhais is a renowned specialist in the field of family law and leads an established team of legal consultants and lawyers across the United Arab Emirates. In addition to family law, he also specializes in inheritance law, civil and criminal law, maritime law, and other related fields. After years of practicing as a lawyer in criminal and public law, he moved to Dubai in 2006, where he's continued to expand his work as a legal advisor and leader of Al Rawad Advocates and legal consultancy. So thank you all for being here today, and I will hand it over to Byron James to start today's presentation.
Hello, thank you very much for joining us. Hopefully you're going to find it interesting to hear us speaking to you. Just to recognize how amazing this event is, I think we have Jessica is in Portland, Oregon. We've got Dr. Hassan, who's in Dubai in the United Arab Emirates. We've got Andre, who's in London, England, and me, who's in Bali in Indonesia. So we're almost covering the whole world with our participants here, which is great. Just before we start, I just wanted to say that I think the people who are attending this talk deserve a lot of credit, because one of the most misunderstood areas, I think, of the world legally is the Middle East. I think that whenever I come across countries, particularly judges in those countries, they seem to have pretty strong opinions about the region. And then when you ask them whether they've actually been there, they have not. And actually, when you think about what's happened, particularly in the UAE over the last few years, there is a huge revolution going on. A lot of the laws have been changed, which affect culture and society quite a lot. So now you can have relationships outside of marriage. Drinking alcohol is no longer illegal. There is a new, which we'll come on to shortly, civil family regime in Abu Dhabi. And it is increasingly the most progressive country in the Middle East region, UAE. And for that, it deserves huge credit. It's a very brave thing for it to do. And I hope that by doing talks like this, more and more people can understand what a brave and terrific endeavor it is for them to be doing. So let's move on to then talk about family law specifically in the UAE. Ultimately, there are a number of different regimes within the UAE that apply to various people. Whether it applies to you depends on which emirate you're in. So there is the Emirates, there are 7 Emirates in the UAE, but the Emirate of Abu Dhabi has one distinct regime, and then the 6 other Emirates have its own scheme. There is a law is applied to Muslims and non-Muslims in the 6 Emirates, and there is a law is applied between locals and non-locals, whether those non-locals are Muslim or not, as long as they don't come from a Muslim country, in Abu Dhabi. So there are different schemes which apply to different people depending on where they're from, their religion, and where they live within the UAE. But Dr. Hassan, thinking about these different laws, before we come to Abu Dhabi, I just wanted to ask about the new non-Muslim law that came into effect on the 1st of February 2023. My understanding is that there is no specific court yet for the new non-Muslim law, but it is applied in the same personal status courts as were applicable before by the same judges, still in Arabic. So it's only in Abu Dhabi that English is allowed. So all the proceedings are in Arabic. The only lawyers who are allowed to attend are Emirati lawyers to be advocates. So if we have the same people, same judges, same court, same language, but a different law, why would we expect there to be a different approach to these cases?
We have to differentiate. First, I would like to thank you, Byron, for such amazing introduction. I agree with you that the approach could be the same, but still we have different outcome, depends on many factors. We have seen successful cases where foreign law could be applied. Unfortunately, we have a lot of restriction. For example, if we would like to apply foreign law, we cannot apply it if one of the parties is dual citizen. So we will have to apply the new law, which you just referred to for non-Muslims. The new federal law doesn't have executive decree yet, unlike Abu Dhabi law, where we have a detailed executive decree. Still in Dubai, we have the principle listed in the law. In the civil procedure law in the UAE, we could have trials in English, but still till now it's not applied in Dubai, but it's expected at some point to be done. You are right that right of audience is given to basically to local lawyers, but still there is, according to the new changes of law, it's expected to have rights of audience given to expat lawyers, although it's not applied yet, but it could come on the way. We could see till now quite different outcome. It's not significantly different from the previous cases under the old laws, but still we have some difference. And we expect in Dubai that the situation would go in different direction with time. In Abu Dhabi, luckily, I know that you are practicing there. The situation is somehow better, or the rights given to the wife is much bigger than the rights given in Dubai. But we expect soon in Dubai to have executive decree, and it's more likely to give more rights to the wife rather than the rights given under the existing laws.
Yeah, so interestingly, my understanding of so we have the new non-Muslim law that has come in from the 1st of February. And essentially, is it correct that one of the main changes of that non-Muslim law is to remove the previously restrictive 3-month limitation on spousal maintenance? And it's created a new concept called alimony, which can be for as long as the court determines. Would you agree that that's one of the main changes?
There are multiple changes, to be honest, Byron, but we have article in the new law says that whatever is not organized in this law shall be taken from the old law. And this article is creating now confusion. Since we don't have executive decree yet, we don't have Supreme Court orders yet, since the law was just issued 3 months back. So still we could see judgments in both directions. Some judgments would say that whatever is not listed in the law shall not be applied. And other judgments would say whatever is not listed in this law shall be taken from the previous law. We don't have much Supreme Court orders yet to clear the conflict, and we don't have the executive decree yet. So in general, what we do now in real cases for expat, for non-Muslim in Dubai, we argue that whatever is not organized in this law shall be extracted from different laws. And this strategy did work with us in many cases. Till we reach the Supreme Court, which is not yet the point where we are in, I cannot give you a definite answer. But all what I can say that what we do now, we take whatever is not listed from this law, we extract it from different laws, and we get it applied, and it does work.
Well, it's understandable because the law has only been operable for 3 months now. So it's obviously very, very new. And as you say,
usually to interpret the law, usually to interpret the law, we need to refer to Supreme Court orders or executive decree. And both of them are not available yet.
And we don't have a procedural rules yet either. So the procedure is still not clear. And one assumes, Dr. Hassan, that in the future, there is likely to be new non-Muslim courts as well in each Emirates, just like in Abu Dhabi. So is it fair to say then, for those listening who are thinking about foreign convenience arguments, because obviously that's one of the main things that people would be interested in, when a case comes up where it's a choice between, let's say, Dubai and a state in America, is the answer, it's very early days and it's not presently easy to be too precise about how the law is going to take shape going forward for potential litigants? Is that a fair summary?
That's fair evaluation, I would say.
Yes, but Abu Dhabi is different. And in
Yes,
Abu Dhabi,
absolutely different.
we have the new civil family court. I actually appeared in it this morning. It's been going since January 2022. So it's now been going for longer, so about 18 months, thereabouts. That takes place in English and in Arabic. We do have law number 14 and regulation number 8, which provides us with a lot more detail about what the law allows. Could you just explain in your mind, how is the Abu Dhabi Civil Family Court financial remedy regime different to that which is provided under the new non-Muslim family law federally across the UAE? How are they different in your mind?
We have big difference. Mainly the executive decree is the one which made such big difference. For example, the factors which are used to evaluate the amount given to the wife, it's around 15 factors in Abu Dhabi. In Dubai, it's much less. In Dubai, it's much less than Abu Dhabi. In Abu Dhabi, the wife would have the right to claim minimum 25% of last annual income of the husband, multiple by number of years as a lump sum claim. We don't have such specific basis.
So that's important. There's a specific formula approach in Abu Dhabi.
Exactly. And this formula is talking about.
And so that formula prescribes outcomes with the idea that all you do is put in the numbers and the formula tells you what the right outcome is.
Yes, and the interesting part that this formula is talking about 25% as a minimum. It doesn't put it as a fixed amount, but it's minimum. We saw cases where it might be awarded more than 25%, depends on number of years of marriage and multiple other factors listed in the law, the 15 factors which I refer to.
So for those listening, it's very important. So I want everyone listening here to take a pledge that they're never going to say UAE family law, because there is no such thing as UAE family law. You have to be very clear about which emirates we're talking about. And if we're talking about Abu Dhabi, we can say to a judge in America that it takes place in English, so that's helpful for expatriates. It is a prescribed formula, which is again helpful to predict outcomes. And so would you agree, Dr. Hassan, that it is easier for a foreign court to look at Abu Dhabi and say that is a more viable foreign convenience alternative than, for example, Dubai at the moment?
It's quite difficult to give such direct answer. I would say it's up to the court discretionary power outside, because in Dubai, even if it's in Arabic, we can use legal translator. Will the foreign judge consider using legal translator as an efficient process or not? That's something subject to their discretionary power. But of course, till now in Dubai, we don't have family law process in English. It existed, it has been established in the civil procedure law, the federal one, which means it will be applied in Dubai at some point. Till now, it has not been established yet. Till now, we are using the legal translator system. Whether it's efficient or not efficient, that's something has to be evaluated by the foreign judge.
As impressive as the new non-Muslim regime and the Abu Dhabi Civil Family Court is, there are still some limitations that aren't there from an international family law perspective. So help me if I have any of these wrong or right. They don't deal with assets based abroad. Is that correct? It's only that which is within the UAE.
That's true.
And as a result of that, they don't do pension sharing orders.
That's
because obviously
true.
pensions don't exist in the UAE. They don't in either Abu Dhabi or in Dubai. There's no matrimonial property regime, so they're not looking to share that which was accrued during the marriage. That's not the purpose of the law. Is that fair?
That's true. Although we have in the new laws, both laws, Abu Dhabi and Dubai, we are talking about the financial portfolio of the husband. And the definition of financial portfolio is unclear. Does it include the financial portfolio in the UAE or UAE and outside? Practically, what happened in reality, that we work only in the UAE. But when you read the wording of the law, it does not specify it to the UAE.
Well, can I ask you something about the law? Because so this is a very unfair question, Dr. Hassan, so I apologize to you in advance. The law specifically says it does not discriminate on gender, correct?
That's true. That's true.
Which is a terrific inclusion and something which should be very applauded. And of course, in the talk that we did before, we talked about children law and the new regime, and of course, joint custody is the starting point. You don't discriminate on gender for parents. It's amazing. How then can you explain to me, a few paragraphs later, having said it doesn't discriminate on gender, why does it say a man will pay a woman money?
But we have in the executive decree of Abu Dhabi law, the right given to both spouses to claim the financial claim from the other one. Yes,
you're saying that there's a way around it. You can, there is a way.
There is a way, yes. There is, because this
That's
point I
very-
investigated previously. There is a way. I can tell you the article exactly, the article number.
Yes.
There is a specific article in the executive decree is referring to the rights of the spouse, regardless their gender, to claim money from the other spouse. Other articles of law does not give the same right. It talks about wife, but we have only one article is giving this equal rights.
Very interesting. And so in your experience, Dr. Hassan, if you have parties who want to widen the scope of a financial order because they don't want to have to do it all again in the States or Europe or somewhere else, if you presented the Abu Dhabi Civil Family Court or the Dubai Personal Status Court with an order that said you can have the house in Michigan, you can have the shopping mall in Washington, would the court accept an order with assets based abroad, or would they just say, no, rejected, we don't have those powers?
There are no rights over assets, but there are no rights over the financial portfolio. So if in theory, if we could prove that the financial portfolio will include all of this worldwide assets, then it might be considered in evaluating the amount decided to the spouse. The article which I was referring to, by the way, is article number 16 of the executive decree in Abu Dhabi laws, which is referring to any of the spouses, not the wife precisely. This could be used in case we have unfair position for the husband, like if the wife is wealthy and the husband is not. However, the rest of articles doesn't help.
Well, as instead of instructing you as an expert in one of my cases, as I've got you here, I want to ask you a question, save my clients some money. I recently got a sole custody order for a father in the Abu Dhabi Civil Family Court. It's the first time that's ever happened. But the law, the financial provision on a divorce doesn't allow a father to receive alimony for a child, even though he's the sole custodian. How do we get around that?
Article 16.
Article 16. I was just going to make a note. Just give me a minute.
That's the only way. The rest of articles doesn't work.
Very helpful. Now, moving on, speaking of alimony and maintenance. So in England, Dr. Hassan, there's a huge argument going on, which Andre will know all about, between two High Court judges, Mr. Justice Moore and Mr. Justice Mostyn. One believes that you should do a formula-based approach, and you take income, you do various bits and bobs to it, and then it comes up with a percentage that you should pay for your children, depending on how many children you have. Mr. Justice Moore says, no, that's ridiculous. You've got to do a budget-driven approach. And if you are satisfactorily bored and have an hour free, Andre and I could sit down and talk to you all about the different ways in which one can calculate child maintenance. In fact, Andre, we have indeed on many occasions done that to various people. Tell me, Dr. Hassan, how do you predict maintenance, either spousal or child, or alimony, as it is called, outcomes, when there's no statutory scheme, there's no case law? How can I say to my clients what is likely to happen as an outcome with regards to either spousal or child maintenance?
Look, Byron, you know, on daily basis, we are meeting clients with similar situation. To be honest, for the last 3 months, I stopped giving any expectation. I just tell the client, what do I have in the law and what we are planning to do. But the expectation with the outcome, I don't think would be practical, because to be honest, I saw judgments. Every week we are getting judgments in according to the new law, and I cannot find pattern where I can follow. I could see more than one scenario, and all of them could happen equally. There is no basis where I can see the judge will follow a specific direction. Even in Dubai, for example, although the law is talking about joint custody, it is very rare to get sole custody, to get the custody joint. Most of times the custody is given solely to the mother. That's what we have now in Dubai. But the law doesn't talk about it in this way. The law is clearly talking about joint custody as a default position. So in general, I try to avoid expectation and I just go through the law. We expect the situation by next year will be much clearer when we will reach the Supreme Court and we'll have well-established legal principles. But for now, I would say for Muslim, we have our clear formula, which is used to calculate the expenses. For non-Muslim, we have very general principles, which we try to tailor it on each case to serve our interests.
So you would say a blank canvas at the moment. Depends.
I would rather prefer not to give any promises, to be honest.
Yes.
I would just refer to the articles.
Depends how persuasive your lawyer is, I guess. Might be one way of putting it.
It will be easier next year, I expect. When the Supreme
Yes.
Court will issue the decision, it will be much easier.
I understand. Now, moving to you, Andre. One of the things that has been quite surprising for me looking at the new regime, and maybe for those listening, you can get divorced in Abu Dhabi, and I think Dr. Hassan, Dubai as well, in 30 days. Do you agree with that, Dr. Hassan, Dubai as well? So you
In
can
Dubai,
be,
in Abu Dhabi, it's clear 30 days. In Dubai,
yes.
it's around 30 days, I would say. It might take
Okay,
a little bit more, but within the range of 30 days.
Abu Dhabi takes pride in saying it's 30 days, right? They say it's the fastest in the world, which is remarkable. From the time you issue to getting your final divorce order, 30 days. And that's no fault divorce. So you don't need a reason. Only one of you needs to be resident or employed through Abu Dhabi to establish jurisdiction. And so you could be in a situation where someone can obtain a divorce very quickly. And as far as my understanding is, that the only ground for opposing it is jurisdiction, by saying that the Abu Dhabi court doesn't have jurisdiction to make the order. And of course, as I've already said, it's actually quite easy to establish Abu Dhabi having jurisdiction to make the order. So Andre, when we think about that, does this give you, as someone working extensively with the UAE, but from the outside as an English practitioner, would that give you any cause for concern about recognition of a divorce? And let's frame it a different way. A divorce that has been obtained within 30 days, where there are no financial orders made during that process, because the financial orders only come after the divorce, where one party has no basis for objecting on, say, foreign convenience grounds, no basis to object on any other reason, let's say financial hardship or, I don't know, religious reasons. They literally will be divorced in 30 days if Abu Dhabi has jurisdiction and the other person wants to.
I mean, it's tricky, isn't it? Because, you know, for the reasons that Dr. Hassan has just been explaining, the whole scheme is still quite new. And so we'll need to see how cases come out. I mean, as a starting point, I don't think the fact that the process is quick is of itself a reason why divorces wouldn't be recognized. But some of those other issues that you've raised on a case-by-case basis, I think might lead to some arguments being open to litigants in England and Wales in particular, arguing before the English courts that a divorce obtained within that sort of procedure isn't one which should be recognised. I think I'll probably need to unpack that a little bit just to explain the regime as it applies in England. So English law, and I don't think it's very different to many common law systems, and I think probably many states of the United States will have a similar approach to things, is that generally speaking, English law will try and recognise foreign divorces as much as it possibly can, because there's a general principle within English law of international comity, respect between nations, respect for different cultures, respect for different legal systems and the laws of different countries. So in England, there's a distinction brought between divorces which are obtained through proceedings and those which are obtained by means other than proceedings, because in some cultures you can obtain a divorce very informally, particularly a religious style of divorce. And the distinction is set out in Section 44 of the Family Law Act 1996, which is our governing piece of legislation in respect of that. And generally speaking, the requirements for a divorce that's obtained not in proceedings is more stringent than that which applies in proceedings. But proceedings from this point of view in English law, you need to see in a way that probably to the eyes of a Western lawyer is a much broader idea of what proceedings are, because they're not talking about just a normal court-based process where there is some sort of hearing or some sort of adversarial process. Proceeding simply means that there has to be some degree of formality around it. So, for example, in English law, a pure Sharia talaq, where a husband simply pronounces talaq unilaterally, which would be valid within Islamic law as a divorce within the religious context, would normally not be recognized as a valid divorce for English purposes. But where it's backed by some form of registration or some sort of formality behind it, so that a husband pronounces talaq and then goes down to the mosque or to whatever the authority is and has it registered, that has been deemed in English law to be a procedure. So there's no doubt in my mind that what we're describing here is a process which, even if it's short, is clearly a process which is within a procedure. So the question then for the English courts will be to think about whether there is a reason not to recognize it. And the reasons for not recognizing it are, broadly speaking, only under three headings. One, which is that it's contrary to public policy, is very rarely used and has quite a high threshold for that. The more valid challenges tend to be either on the basis that somebody hasn't had notice or reasonable notice, or they haven't had a sufficient opportunity to participate in the proceedings. And interestingly, those two things are judged in England through the perspective of what an English court would consider to be appropriate notice or to be a reasonable opportunity, rather than one which is valid within the courts that apply. So there's a slightly higher threshold for this. So, for example, some of the situations that you've identified, which if they give rise to real hardship through the process, such as not properly providing with financial means, might possibly be a ground for objection. Certainly, if somebody isn't able to participate in the proceedings because they don't receive translated documents, so they don't understand what it is that's occurring, and I don't know whether it's built into the procedure that if you serve on somebody who is not an Arabic speaker, the documents have to be translated into their home language or not. But clearly, if you received a bundle of Arabic documents when they've been served on you, knowing that you are not an Arabic reader or speaker, I think would probably cause an English judge to have real concerns as to whether you've received notice. But if all of those boxes have been ticked, you've had notice of the process and the local procedures have been carried through normally, in a case where there's no obvious hardship caused as a result of that, I don't really see any reason why the English courts wouldn't give recognition to it just because it's short.
But could you say, I'm asking you to carve out arguments here on the hoof, but could you say denying the ability to argue foreign convenience is a form of a denial of an opportunity to participate?
It might be. Yeah, I mean, it might be. If there genuinely is no way of challenging the jurisdiction of the court, and you are not able, therefore, to participate and challenge it, and the decree has been obtained on the back of that, I can certainly see why that would give rise to an argument under the Family Law Act, whether it's under the opportunity to take part procedures provision, or indeed the contrary to public policy provision. You could probably run it under both of those thresholds. Whether it would succeed, you know, I think that's a matter which we'd have to come see, but there's certainly a valid argument.
Well, in England, we have the Part 3 1984 Act, which allows you to receive financial relief after a foreign divorce. And that ameliorates some of the prejudice that you might otherwise suffer. So as we've said, doesn't make orders over foreign property, no pension orders, etc.
Yeah, I mean, I think we're talking specifically about the divorce itself at this stage, aren't we? And of course,
yes,
the way things have progressed even in England in the last few years has been quite dramatic, because you know, we had a fault-based system up until last year, whereas now you can get divorced with no fault in England as well. So there's effectively a right to divorce now, subject to arguments about forum or jurisdiction. The time periods in England are much longer because it's a 6-month period rather than a short, quick divorce as you've described. But I think the culture has now changed to the extent where defending a divorce is actually quite difficult on anything other than jurisdictional grounds.
well, as the people who've joined have been kind enough to come and join to hear us talk, let me let you all into what I think is a bit of a tactical tip, although I think it's a very annoying tactical tip. One thing that you could do, obviously, is rush to get your divorce in, let's say, Abu Dhabi within 30 days, and then do nothing, right? Because obviously, if the divorce is recognized as valid in England, you can't issue a divorce in England, or indeed anywhere else in the world that recognizes.
Right, the marriage is gone, so you can't dissolve.
Because you can't be divorced twice.
Yeah.
You can't issue financial relief after a foreign divorce in countries that allows that, usually until the first court has made a financial order, because obviously the whole point is it's supposed to be a sweep up remedy, not a primary remedy. Is that, would you agree?
Yeah, you're expected to exhaust your remedies in the other jurisdiction first. Yeah.
So tactically, one might be best advised to rush to Abu Dhabi or Dubai, get your divorce as quick as possible, do nothing, and then try and slow down the financial process for a period of time. As we've already heard from Dr. Hassan, we're not clear on the procedure rules. We're going to talk in more detail shortly about what the process is, but let's just say it's unclear how long that process might take. as opposed to England, which might be a bit more clear. What would you suggest, Andre? Is it possible to get orders internationally to stop or slow down that process? And if it is, how would they work in practicality?
Well, it's a slight misnomer to say it's an order obtained internationally to stop it, because no court of any country has jurisdiction over the court of another. So you can't obtain an order in.
Well, you can get an in personam order against a person.
Yeah. So you can only get an order against the litigant. So you can't get an order in London telling a judge in Abu Dhabi not to proceed with the proceedings. And no doubt it'd be useful to hear from Dr. Hassan as to what he thinks the response of a court in Abu Dhabi might be in the event that an order such as this has been made. But there is scope, certainly in England, as in many jurisdictions, to obtain an anti-suit injunction. So if you've started proceedings in England and there are rival proceedings in Abu Dhabi or in Dubai, which you expect will probably go through much quicker than you can deal with any process in England, you can ask the court in London to make an order preventing the respondents of the English proceedings, who's no doubt the applicants in the Middle Eastern proceedings, from proceeding with their divorce in Dubai or Abu Dhabi. Now, the effectiveness of that order is going to depend on whether it actually slows the process down in the other court when they are given notice of it. So, for example, an English court might decide not to proceed with a divorce if it hears there's a dispute in another country and decides that other country should deal with the dispute first. But if the courts of that jurisdiction are not going to slow it down, you're relying on it being an in personam order. It is an order telling the husband, if it is the husband, that he cannot pursue his proceedings in Abu Dhabi. And the effects of that is going to be limited by whether he is bothered as to whether he breaches the London court's order. So if he's not present in England, has no assets in England, and has no interest in returning to England, he may well decide, well, I don't care if I'm in breach of a London order because nobody can touch me about it.
There are things you can do through judgment summons and Interpol and red notice warnings, but I take your point. Before we come to Dr. Hassan about the efficacy of such an order, in your mind, Andre, because obviously we have to demonstrate bad faith, don't we, to get a Germain injunction? You're not entitled to an anti-suit as of rights. You have to show some form of malfeasance to obtain it. Do you agree?
Well, all you have to show, you've got such a strong case in England that it would be quite wrong for the other one to take priority just because somebody's got in there quicker or can get through it quicker. So if you've got a very strong case on jurisdiction, the court might make the order to prevent the case going through.
Do you mean that England is the more obvious and natural forum?
Yeah.
So, okay, so in your opinion, if, and obviously I was involved in a case in front of His Honour Judge Hess where this exact thing did happen, of course, but if you are someone who's looking to try and slow down Abu Dhabi, you believe that it would be possible if you could persuade a judge in England that England is a far more natural forum, and or that the other side is trying to use the Abu Dhabi or the Dubai proceedings as a weapon, if you like, with bad faith, you could obtain an order, an anti-suit order from the judge.
Yeah, it's going to depend. It's going to depend on it's going to depend not on which court is going to give the more favourable outcome financially. It's about which court the parties have the closest connection with. So if somebody's pursuing a proceedings in Abu Dhabi or Dubai on the thinnest grounds, because they've only been there for a very short period of time, there are no assets there, their connections with Dubai are very limited, and they're clearly pursuing the proceedings there purely to get financial advantage, whereas all their connections are with England, the English court's going to be sympathetic to your application in those circumstances. If a couple have lived in Abu Dhabi for 10 years and one of them issues proceedings there, I think the English court's going to be a lot more circumspect before it stops somebody bringing proceedings in a state which has become their home and in which they've got an established centre of interest.
Can you get one of those orders within 30 days?
An order preventing proceeding, yeah.
Well, because otherwise they're divorced, right? Because the divorce goes through in 30 days.
Yeah, I mean, an injunctive order can be obtained on an urgent basis. It can be obtained. I mean, whether it's effective is the second question, but yes, the order can be obtained in very short order.
Let's ask Dr. Hassan. So, Dr. Hassan, Andre has obtained hypothetically an order from the English courts ordering that one of the parties cannot proceed any further with let's say the divorce in the Abu Dhabi Civil Family Court, because the English court has determined that England is by far and away the most obvious place for the divorce to take place in. What would the Abu Dhabi judge make of that order? Would they consider it at all, or would they just throw it in the bin?
I don't think that the order will be valid in the UAE, since one of the requirements to recognize any foreign judgment is to make sure that the UAE courts doesn't have jurisdiction. Here, the court has jurisdiction, and the Supreme Court indicated clearly that jurisdiction is not right of the court. It is their obligation to take the case. Since it's their obligation, it shall not be fulfilled or removed by any other foreign court order. However, I saw real cases in situations like that. And my client, since he had the order to freeze the proceeding, he had to instruct me to freeze the proceeding, and we had to freeze the proceeding. So the power of the judgment will not come from the enforceability in the UAE, but it will come from the fact that the client himself is subject to the UK jurisdiction, and he might have legal complication there.
Yeah. Well, can I ask you then, Dr. Hassan, about this Lencore decision? So Lencore was a case where I believe it was about a bounce check, wasn't it? And the English Court of Appeal upheld a Dubai judgment. And so the Ministry of Justice in the UAE published a decree saying that they would now consider themselves duty bound because of one of the articles to reciprocally enforce orders between England and the UAE, which is beautiful. It's beautiful that England and the UAE are such friends now, which is great.
That's true.
Have you seen that principle applied in a family law context?
The principle, the letter which you are referring to, issued by the Minister of Justice, which requested from the Dubai judges to recognize the foreign judgment on basis of equal treatment, since England accepted to recognize the UAE judgments. However, recognition of the foreign judgments from England or from any other courts shall not contradict the civil procedure law in the UAE. And the rule which I refer to is part of the civil procedure law. So previously, it was not possible at all to recognize the UK court order, since there was no treaty and there was no equal treatment principle. The situation now, after the letter which you are referring to, we can get the UK court order recognized if it fulfills the requirement which is requested by the civil procedure law in the UAE. And one of these requirements that the court shall not have jurisdiction over the case. Of course, there is additional requirement like the certificate of finality, which is a big deal, by the way. We are not able to get it easily from England. The local laws is requiring to have a independent certificate to indicate that the foreign judgment is final. Getting such certificate from England it cannot be appealed anymore, and it cannot be objected by any higher court. Getting such certificate is not easy task, as I can see, and it created issue in enforcement in the enforcement process, even if there was possibility of getting the judgment enforced. However, to answer your question, yes, there is equal treatment principle between UAE and England. Yes, in general, we can apply the foreign judgment from England in Dubai. However, we still have to follow the restriction listed in the UAE civil procedure law. And one of this restriction is the lack of jurisdiction of the UAE courts if we want the foreign judgment to be applied.
Thank you very much indeed. Andre, we've got a question from our audience. It says, how far does the panel, but in this case you, Andre, think that the new non-Muslim laws will influence parties' decision to issue in the UAE over UK? And will the view of London being the divorce capital of the world, I love when people say that as if London is its own jurisdiction, which obviously it is not, will change with more proceedings being issued in the UAE? Is that what the UAE are hoping for? So Andre, do you think that this is going to cause fewer cases to be issued in England now?
Well, the issue, I suppose the question really will be not so much the issue, but the question whether you take a jurisdictional argument if it's challenged in due course, and whether you just let things take their course in the UAE. I mean, there's two aspects to it. One is that it is probably going to be more difficult, as you've experienced in the case that you mentioned with the Hess decision, where you were challenging jurisdiction being, I think that was a Dubai case, wasn't it? The one where
Abu Dhabi
against you.
Abu Dhabi Civil
right.
Family Court.
So the fact that, at least in theory, the courts in Abu Dhabi or potentially in Dubai under the new decrees will apply English legal concepts and give meaningful financial orders to husband and to wife may well mean that it is far more likely that if a court takes the view that it is a convenient forum and an appropriate forum, that it will be, and that those proceedings will take priority. So the arguments that we used to have, which were basically, well, if you're particularly for the wife, you were probably going to receive very little by way of financial support or remedies in the proceedings in the UAE, and now potentially much weaker. Whether that argument stands up, I suppose, will depend largely on exactly how the courts there grant financial relief. So from that point of view, people may take the view, well, actually, I'm more likely to lose a jurisdiction argument now than I was a few years ago. But the other aspect of it is also to consider whether you've got the Part 3 jurisdiction, which is the jurisdiction that exists in England, to bring proceedings following a foreign divorce for financial relief, which is effectively in addition to the relief that's been granted to you in the primary jurisdiction where the divorce took place. Now, where that is available, it's not going to be available in every case, because it's only going to be available in those cases where the applicant for that relief qualifies. So if they've got English domicile, or they achieve English habitual residence because they return to England, or indeed they've got a family home which is in England. Those are the main criteria for the jurisdiction for Part 3. If you know you've got that safety net, in a way, there'll be less reason to have an expensive jurisdictional dispute trying to get your primary case brought in England, because you can just let the UAE process run through. If you get what you want to achieve through that, fine, you've got the justice you wanted. And if you don't, you've got the safety net potentially of Part 3.
If I may, that was the exact situation we were confronted with in my Hess case. And of course, it's easier said than done, isn't it? Because you're asking your client to go through an uncertain system, getting an outcome. There's no guarantee that you'll be at the end of that process, at the end of the bracket, which the court considers reasonable to give you permission to bring a Part 3 claim. It might be on the cusp.
Those are no doubt all the arguments you ran in that case, which were successful with Hess, you know. So,
which were not successful with Hess.
The word of warning that those arguments, which I think 3 or 4 years ago would have probably swung it in favour of the English court, saying actually we'll get on with this and we'll treat this as an English case with an English divorce. Now possibly going the other way, which I think will cause people to give some thought before they embark on what may be a somewhat sterile argument if they've got a Part 3 live claim there as a fallback in due course.
Can I ask you this, as an international family lawyer, Andre, not just as an English lawyer, but as an international family lawyer, Dr. Hassan is obviously the #1 expert on UAE law, and I'm sure most of the people in the audience have probably asked for an expert report from Dr. Hassan at some points in the past. If not, I'm sure they will in the future. But we've heard tonight that even Dr. Hassan can't be more precise about what the law is going to be, because we don't know yet, because it's very embryonic. But does that, exactly, as an international family lawyer, does that cause problems then when it comes to foreign convenience arguments? How do you deal with an expert report in front of a judge that just says, Inshallah, Dr. Hassan, you know, we hope that it will do well, but we don't know.
I would just say
it is a real problem, isn't it, for us? Because the English, you don't know whether the English judge is going to say, well, it sounds like they've got a scheme now that's going to treat your claims fairly and make proper provision for you, so therefore let's let it get on. Or a judge who may take a more cynical view and say, well, I think that actually the regime there is one that isn't going to provide you with a fair outcome, and therefore it should be here. I mean, you're always on stronger arguments, in my view, on jurisdictional points about trying to make your application not based on what the outcome will be, but on your connections with that jurisdiction in the first place and where the assets are. You're always going to get stronger arguments in relation to that, rather than asking a judge to speculate as to what the outcome of those proceedings will be, because most judges will say to you, well, rather than speculate, why don't I just let the process continue, and then we'll deal with it under Part 3 if you say that it's not been sufficient.
Dr. Hassan, were you trying to jump in there? Sorry if we cut you off.
No worry, but I was just saying that I would say what the law says. I wouldn't give any expectation of the outcome. The law is quite unprecise. It includes general principles. I would just say the general principle and leave it to case per case basis.
Yes. Yeah. Well,
whatever we have in the law, we can claim, but what we will be able to get it or not, that's a different story.
I guess it's interesting, isn't it, for judges around the world who are looking to balance up this new courts and this new regime that they will know nothing about. That's why His Honour Judge Hess's decision was so interesting, because he gave a lot of confidence in the Abu Dhabi Civil Family Court. He said, I trust them to try and do a good job first time around, which was amazing. Okay, well, can we?
But that largely is the approach that English law takes. I mean, it tries, English judges nowadays try to be very careful not to have a chauvinistic attitude and just assume that we have got a better system than anyone else. So they tend to respect the foreign jurisdiction to do a decent job and then to mop up in the event that it doesn't.
That's not how they've always treated the UAE, Andre. So
not historically, no, but that's the general approach they've taken. I think now they are likely to. Status
law, I think that they didn't do that. So it's a change. The tide has changed, I think, because of this new non-Muslim.
Yeah, I
think it's made them feel more comfortable with it. Okay, well,
look, Byron, we have to keep in mind that the situation we have now is not expected to last more than 1 year.
Yes, I understand that.
So I don't think that evaluating the whole law on base of temporary situation would be a fair evaluation.
And yet we have
with time we will get judged.
It's an interesting perspective on this, Byron. I mean, there's a 1984 case called Zal and Zal where the English court refused to recognize a Dubai divorce because at that time the Dubai divorce process was effectively secretive. You know, the wife wasn't allowed to attend the hearing, didn't participate at all, and so on that basis the court took the view it wasn't going to be recognized. The Dubai procedures then changed so that the wives were able to participate, and as you know, for well over a decade now, Dubai divorces have been recognized in English proceedings, so long as the notice requirements have been covered. So, you know, laws adapt and change, you know, so, and there's clearly a directional steer now being taken by all of the Emirates towards trying to integrate themselves more with Western legal systems in a way that Western legal systems are able to respect. And that's a dynamic process, which I imagine is going to continue over the next 5 to 10 years.
Yes, I understand that. Well, look, let's just go back to the practicalities of the system. Dr. Hassan, when we think about financial disclosure, there is no duty of full and frank disclosure on the parties, is my understanding. You are required in Abu Dhabi to fill in your assets with your post-divorce financial application form. So you, as the applicant, put in what you have. And then if there is a dispute about what there is, the court appoints an expert, and that expert's likely to be an accountant, probably from a very well-known firm, who will come in and do a report. Have you, well, not have you, are you aware whether that's actually happened yet? Has an expert been reported in that way? And if so, is there anything you can share with us about what that looks like as a disclosure process?
In light of what, Byron?
Well, as opposed to, for example, what I mean is, in England, for example, you wouldn't bring in a third-party expert to do a report. The duty is on the parties. But in Abu Dhabi, it is the duty of the expert to do the report, and then it's from that report that the court bases its findings. So that, I think that's quite an unusual way of doing it. So I think it would be interesting to hear.
That's true, but we have to keep in mind, yes, but we have to keep in mind that we have 3 ways to discover or to do the discovery. First one, when the husband would fill the form in the beginning at the registration in Abu Dhabi, it doesn't exist in Dubai.
Yes.
Second option is the request for inquiry or investigation from the banks or from the authorities to see if there are any assets registered under the husband name. The third option is using the expert or the accountant expert. We have multiple cases now in Abu Dhabi where it goes with, at this stage, we don't have much reports yet issued. There are few reports, few numbers only has been issued in the whole Emirates of Abu Dhabi, but most of the cases is still running where they are still in preparation at the preparation stage. But what I would like to stress on that the expert task is not the only way to discover where the husband is, where the husband money is. We can try to use the investigation as a strong tool, especially if we have doubts that the husband is hiding any information.
So I'll ask you about that in a minute. What powers does the expert have to investigate the finances of the parties?
Legally, he has the right to visit banks and the authorities or to send them letter to disclose information. And it's very common that experts are doing this regularly. They are
Can
very
they go
familiar
to
with this
the-
process.
Can they go to the Dubai Land Department?
Yes. But usually
they
what
have
they
to
do, they
comply?
send email. Yes, they send email. Usually what I see, because I dealt with cases,
Yes.
using the expert or the accountant is not practice here, is not a practice to be used in the UAE for the first time. It has been used widely in the civil and commercial cases.
Yes.
So it works under the same process, and part of their process that they have the power from the judgment or from the court. The power is listed in the judgment. They have the right to communicate with authority and request for disclosure. What I see in reality, they will send an email to the authorities and the authorities will respond back. Sometimes the authority doesn't respond and the expert has to move physically to the location. That might include RTA to check if there are cars registered under the husband, land department, banks, and the most important here are banks, by the way.
Yes.
Sometimes you might ask them to communicate with the central bank. Previously it was possible, then not possible, then again possible. Getting the information from central bank is not easy. But getting the information from the banks, if we know the bank's name, is very easy task.
And free zones? Can they go to a free zone?
Free zones as well, of course. Any governmental body.
And what about, so in the UAE, I'm sure the people listening might not know this, but they don't have trusts. They have something called foundations, which are similar to trusts in ways. How are foundations dealt with by the expert? Can they get after the foundation?
Look, we have trust as well, but it's not commonly used.
No.
Not commonly used. Most of people, they like to use foundation. To be honest, I didn't come across a case where we had to go through foundation. So I wouldn't comment on this point.
Could the expert walk into the new family business center at the DIFC and walk up to Dr. Tariq and say, right, I open your drawer, I need to go through it, please, and find the records of these families?
Legally, yes, but there is a chance that he might be requested to provide additional authority.
Dr. Tariq will be busy that day. He'll say, come back later. I understand.
Legally, it's possible, but since it's two different courts here, it falls under different jurisdiction, he might be requested to communicate through the courts only.
And from a court abroad, is it possible for a court abroad to engage the powers of that expert? So if I'm involved in an ultra high net worth case in England, and it's thought that the husband has 100 million dirhams in the UAE, but we don't know how to prove it because there's no, so I think I'm right in saying there's no companies register, there's no public properties register. So these things are all kept very private, unlike England, obviously, where you can search all of those things. Is there a way for me involved in foreign proceedings to engage the powers of that expert to establish the wealth of the husband for the purpose of foreign proceedings?
You mean discovery only?
Correct.
No. Till now, we don't have this tool. Filing a case just for the sake of discovery does not exist. Usually what we do, we file maintenance claim, we do the discovery, then we withdraw the case. As a claimant, you have the right to do at any point. So at some point, you decide that you don't want judgment yet, you change your mind, I want to take my case back. And you can collect the evidence from the file and use it in any foreign courts. That's the only tool used till now.
You've heard that here first. What an interesting insight. Thank you, Dr. Hassan. That's great. Okay, well, look, I think we're going to draw this to a close now. I think we, in our last 4 or 5 minutes, what I'll do is just quickly say, before I say goodbye to anyone, everyone, not anyone, are there any further questions that anyone would like to ask?
There is another one's popped up on the chat.
Please put in the chat. Oh, thank you. Well, it's an extremely long question. Okay, well, let me do my best to quickly whiz through this. What if a husband is a Muslim expat and the wife is a Christian expat? What law should be applicable by the judge, Muslim or non-Muslim, provided that the wife wishes to apply laws of the non-Muslim or the husband? So you've said it's a problem question for the last 4 minutes. What I'll say is this: instead of going through your really long problem question, which you can set us as an exam question later and give us marks. The very interesting thing about the Abu Dhabi civil family court, so you don't call it the non-Muslim family court because it is also available for Muslims, which is incredible when you think about it. The only proviso, because look, I'm not Muslim, so it's not for me to talk about how other Muslims feel. But certainly I noticed in my cases that you had westernized Muslims who felt a little bit, it was unfair that they were being dealt with in the personal status court as either a Muslim or a non-Muslim. What this does is set up a regime where Muslims and non-Muslims can be treated the same under the law in the Abu Dhabi Civil Family Court, as long as you don't come from a country which is a Muslim country and you're not a local. Is that fair, Dr. Hassan?
You're absolutely right. That's in Abu Dhabi.
Which is incredible. Which is incredible if you think about it.
We have to differentiate between the scope of applying the law between Abu Dhabi and other Emirates. In Abu Dhabi, it's about your home country law, regardless your religion. So if you are Muslim from non-Muslim country, you will be subject to non-Muslim law. In other Emirates, it's about your own belief. So if this case, which we are talking about, Muslim husband and non-Muslim wife, if they are based in Abu Dhabi, more likely if they are from non-Muslim country, they will be subject to non-Muslim law. But if the same couple were based in Dubai, we will have to put them under Muslim law, because if one of the parties is Muslim, they have to be subject to Muslim laws, regardless their nationality.
Yes, yeah, fine. Well, there we go. Well, can I just say thank you so much. I mean, look, honestly, we've condensed this down into an hour. One of the most amazing things is to have a brand new family law jurisdiction in the world, in Abu Dhabi, in the Abu Dhabi Civil Family Court, and with the new non-Muslim laws across the UAE. It's very exciting. It's an incredible time to be working with those laws. You've been so lucky to have Dr. Hassan and Andre talk to you about it, because they're both brilliant. So thank you very much indeed, Dr. Hassan and Andre. And Jessica, I'll pass back over to you.
All right, thank you everyone for joining, and the recording will be made available. If you have any questions, I've provided the links to our speakers' web pages in the webinar chat. So you can reach out to each of them individually with any questions.
And you're going to end on a song, aren't you, Jessica? You go ahead, take it away.
No one would ever join one of these webinars again.
Yeah, well, that's why we do it at the end, isn't it? Well, thank you all very much indeed. Do you know what? It's now past midnight in Bali, so I definitely need to go to bed. So good night, and thank you all very much indeed.
Thank you, and thank you to our speakers.
Goodbye.
Thank you. Goodbye.